Good afternoon. My name is Tim Lynch. I am your host for Legal Lines. Legal Lines is brought to you by the Massachusetts LGBTQ Bar Association. We come to you live the third Wednesday of every month. Today our guest will be Gary Busek. He is the legal director of GLAAD. If you'd like to join our conversation, you're more than welcome to do so. Our phone number here is 617-708-3290. Again, 617-708-3290. How are you, Gary?
I'm doing good, Tim. Thanks.
Now, you've been with GLAAD for a very long time.
I have. Almost since the beginning in 1978, though. I started volunteering in 79, I think.
Wow, God bless you. That's really wonderful. And you're currently the legal director. What does that involve?
Well, it really means that we are large enough that we have a legal staff now of 7 full-time attorneys, and we need somebody to really kind of corral us and be the administrative person. But ultimately, I'm just one lawyer among the group.
Well, and just for purposes of the audience, could you remind everybody what GLAAD is?
Well, GLAAD is a nonprofit legal organization working in the 6 New England states to really advance the rights of lesbian, gay men, bisexuals, transgender individuals, and people living with HIV and AIDS.
Yes, and you were the guy, and to just kind of put a fine point on it, you were the guys who spearheaded the marriage litigation, both up in Vermont and then, of course, Massachusetts.
That's correct. With co-counsel in Vermont, we brought Baker versus Vermont, which we thought was going to be a marriage case. And after we won at the Vermont Supreme Court, they left open the option of a remedy to the legislature, and the legislature created for the first time an institution called civil unions. Yeah. We then subsequently brought a marriage case in Massachusetts, which was successful in November of 2003, Goodrich versus Department of Public Health, which said that marriage had to extend to same-sex couples as well as opposite-sex couples. And then ultimately in 2008, we won a marriage case in the state of Connecticut as well.
So basically, all of New England is covered except for Rhode Island and Maine?
That's right. That's right. And we had Maine for a bit. You know, in 2009, the legislature passed a marriage equality bill. The people gathered signatures to put it on the ballot, and in a referendum in November of 2009, they refused to allow the law to go into effect. The community is back this year, and in fact, we, the community, are initiating a statute that would extend marriage equality to all couples who otherwise satisfy the requirements for marriage in Maine. It's going to be on the ballot this November, and we are, cautiously optimistic that over these last 3 years, that Mainers are ready to actually vote on our side of the issue.
They've had more time to think about it, and they're better educated as to what the issues are.
That's right. That's right.
And recently, and the reason why I asked you on the show was because I think it was April 4th was the oral argument before the First Circuit in the DOMA cases.
That's correct.
Now, what is DOMA?
Well, DOMA is called the Defense of Marriage Act, passed by the United States Congress in 1996 when they thought one of the most horrible things on earth was about to happen, that Hawaii was about to allow same-sex couples to marry. As we all know, that did not happen, but Congress acted to do 2 things. First, they wanted to make sure that every state in the nation would never have to respect that marriage if it happened in Hawaii, because they convinced themselves that every gay and lesbian couple in the country had their plane tickets for Hawaii, would get married and come back and then demand to be treated as married in their home state on the mainland. So they said states would not have to respect that marriage. And then in another section, they said for the purposes of every federal law where marital status is considered for extending a benefit, providing an obligation, that marriage would be between a man and a woman only. And that is Section 3 of the Act. That is what we ultimately challenged, when same-sex couples could finally marry in Massachusetts. It never happened in Hawaii in 1996, but in 2004, when couples started to marry in Massachusetts, they found themselves essentially married by the state or by the Commonwealth of Massachusetts and unmarried by the federal government. So for purposes of filing joint income tax, for the purpose of receiving Social Security benefits upon the death of their spouse, whether it was Family Medical Leave Act or any number of other ways in which we all, when we're married, interact with the federal government, our couples were treated as unequal. Essentially, the federal government takes a class of married people, all of the people married in Massachusetts who get the same marriage license, operate under the same benefits and obligations of Massachusetts laws to married people, and takes that group of people and cuts it into two. The different-sex couples who are treated as married by the federal government, the same-sex couples who are not. We believe that's a violation of the Constitution, of the equal protection guarantees of the Constitution, and so we brought a lawsuit challenging the law.
Yeah, you put it very succinctly. So whereas on the state level, the argument was whether same-sex people can get married, when we come to this one section of the federal statute, these people already are married, and so the federal government is discriminating against similarly situated couples.
That's right, because these lawsuits now don't ask the federal government to do anything about whether people can marry. And if we win, it isn't to say that the federal government is imposing marriage on any other state. It simply says that if a state like Massachusetts allows a couple to marry, the federal government has to treat them as married as it does any other married couple.
And as I understand it, you argued first, and actually, let me back up. There are two suits, though, consolidated into one. There was the private suit brought by, I think it was 7 couples, yes. and then there was the Commonwealth of Massachusetts brought a suit as well.
GLAAD has a number of married couples as well as 2 widowers who have Social Security claims based upon the life and the earnings of their widowed spouses, their deceased spouses. The Commonwealth brought a different kind of a claim, urging it's called a 10th Amendment claim, that because marriage belongs exclusively within the power of the state, the federal government was intruding upon that power by effectively eviscerating those marriages in significant ways that the Commonwealth claims intrudes upon their sovereignty. And for example, we have veteran cemeteries in almost every state probably. The Commonwealth has 2 of them. And a veteran is allowed to be buried in that cemetery with his or her spouse, even if the spouse is not a military person. The federal government essentially told Massachusetts, if you bury a veteran and promise to bury his or her same-sex spouse alongside them, you can lose all the federal money you've received to support that veteran's cemetery.
Wow.
So it's one of the bases upon which the Commonwealth sued the federal government. So we both won in the trial court before federal Judge Toro, who declared DOMA Section 3 unconstitutional for violating both the Equal Protection Clause and the 10th Amendment.
What could be more heart-wrenching than a veteran not being able to be buried with their spouse? I mean, I can't imagine. That's unimaginable.
Right.
So Judge Toro ruled unconstitutional on both grounds in each case, and then April 4th, year before, the First Circuit.
And so there's been, the interesting interplay between then the Obama administration, when we filed this lawsuit in March of 2009, so it was early in the Obama administration, they defended DOMA. And I wouldn't say they were defending it the way the Bush administration defended it, because Congress had a number of rationales, it said, when it passed DOMA. And one of them was to defend traditional heterosexual marriage, asserting the immorality of homosexuality, defending tradition, defending the public fisc. And essentially, the Obama administration wasn't willing to make those arguments. But they asserted that all that Congress needed was a rational basis. And it didn't matter if Congress thought of it at the time. As long as there was a rational basis, the court is supposed to defer to the legislative judgment. So they came up with some other rationales. So that's the way we proceeded before Judge Toro. And then in February of 2011, 2011, the Obama administration changed its mind. And it actually may have been February of 2010. I'm losing track of the dates a little bit. And they decided, because of new DOMA lawsuits challenge, that they couldn't take that position any longer. And they announced that they now believe that DOMA is unconstitutional. That transferred the defense of the statute to Congress. And the Republican-controlled House of Representatives came to the defense of the law, hired a law firm, hired a very prestigious lawyer named Paul Clement to defend the law. And so it came to the First Circuit Court of Appeals in an interesting posture, because now it is GLAAD and the Commonwealth of Massachusetts defending Judge Taro's decision that DOMA Section 3 is unconstitutional. The federal government, the Obama administration, at least the executive branch, agreeing with us that it's unconstitutional, but with a little nuance in its position, and the House of Representatives with a full-fledged argument that DOMA is constitutional, and resurrecting some of the 1996 congressional arguments about procreation, heterosexual marriage, and the like.
We'll get into that in a second.
Okay.
You've been watching MLGBA Legal Lines. Legal Lines is brought to you by the Massachusetts LGBTQ Bar Association. Our number here is 617-708-3290. Our guest today is Gary Busek, and we're talking about the DOMA litigation. Let's back up for 1 second. How often does the executive branch do that? Say, I'm not defending this law.
Well, it doesn't happen too often, and the House is consistently reminding the courts that this is an unusual step that the Obama administration took. That's not to say that it doesn't happen. There's actually a statute that Congress passed some time ago to deal with this situation. They anticipated it, and it explains how the option goes to the Congress, one or the other House, to then step in and defend the law. And to give a little bit more of why the Obama administration did this is that they have been defending on what lawyers call the rational basis. If a law gets rational basis review, it means what I said a moment ago. The courts are supposed to defer to the judgment of the legislature. They're not supposed to be activists. They're not supposed to be stepping in and overturning laws passed by Congress. So they generally try to find any basis under which you could say that the law almost just passes the laugh test. It could conceivably be justified even if the Congress was wrong. So the Obama administration in our first lawsuits here was able to say, well, that's the test. The rational basis test is the test because the First Circuit Court of Appeals has said that's the test when a law deals with sexual orientation. We knew that someday a lawsuit would be filed in another part of the country governed by another Federal Circuit Court of Appeals in which the rational basis test might not be the actual answer. In some circumstances, for certain classifications, the courts look more closely at what Congress has done. They apply what's called heightened scrutiny. They don't just give absolute deference to what Congress has done, because there are certain circumstances, and the paradigm case is race, when you think any time a legislative body makes a distinction based upon race, it's suspicious, because it conjures up the notion that, well, maybe Congress did this for not so good reason. And so the court over time has designated certain classes of people, whether it's based on race or sex or national origin or legitimacy, to say in those circumstances, there's enough of a suspicion that there could be something improper going on that we will look at the law more closely. Our position has always been that when a legislative body makes a judgment based upon sexual orientation, that should be subject to more careful look. And when GLAAD filed a second DOMA challenge in Connecticut, and the ACLU simultaneously filed one in New York, that goes to a court of appeals called the Second Circuit, in which there is no ruling yet that sexual orientation is governed by rational basis. And what it made the Obama administration have to decide is, well, where do we stand? Does sexual orientation get rational basis review, or does it get heightened scrutiny? I think to their credit, as a principal legal matter, they decided that the answer to that question had to be heightened scrutiny. Once they made that determination, then they believed that DOMA Section 3 could not satisfy that review. And it made them have to say, we can't defend this law anymore.
It's indefensible.
Yeah.
But, so what we're talking about here then is under the Constitution, there's something called equal protection.
Yes.
And basically equal protection is you have to treat similarly situated people the same.
Right.
And so when the government comes in and sees similarly situated couples in Massachusetts, married couples, and discriminates, then the question is, how does the court value the law? Does it look at it as on basis of rational basis, which you've so eloquently described, or does it put a higher scrutiny standard?
That's correct.
And historically, courts have in race,
Sex,
gender,
yeah, national origin, illegitimacy. Some people would say religion.
it put higher standards.
Put higher standards.
And I take it mainly because, well, at least race, it's in the Constitution.
Yes,
You know,
and they've developed a test for it. They ask principally, has the group been subject to a history of discrimination? And is that essentially that character unrelated to ability to perform in society? And generally we would say as to race, yes, there was a distinct history of discrimination, and there is no relation of color to ability to perform in society. And so when you see then a statute that says something in old days like barring interracial marriage, and you would say, well then what is the justification for that? Because when you've got that discrimination, you've got that disconnect to ability to perform in society, you think something else is going on behind this statute. It might well be
racism.
It might be racism. It might be unjustified discrimination, a violation of equal protection. And occasionally they also look at the factors of political powerlessness and whether the trait is immutable, because you shouldn't be punished in law for something that you really have no control over. So gender, things that generally fit into that character. None of them are immutable absolutely. I mean, race is a bit of a fluid category. Gender can change. Sexual orientation, this is what has been argued about in our cases. Is sexual orientation changeable? Does that make it fall outside this classification that would get heightened scrutiny? But generally, our position on that is really strong. I mean, there has been a history of discrimination against gay people. It's unrelated to ability to perform in society. It's a characteristic that is immutable, particularly when the courts understand that as something that no one should be forced to change. And if you asked a heterosexual person if they thought that their sexual orientation was changeable or should be subject to change, they would agree it's immutable. And that gay people are still a minority and still don't have the political power to create the equality they would like to have if they had power. So we clearly meet the test. The question is, the $64,000 question is the U.S. Supreme Court ready, even though we meet the test, to say that that's the law? Or are we going to continue to be governed by the rational basis test, which we think DOMA can't even satisfy? And that's what we persuaded Judge Toro too, that it isn't even rational in terms of DOMA.
So it's really a two-prong attack here. The first attack being that because gay people have this history and these other issues, any law that discriminates, does not treat them equally under the Equal Protection Clause of the U.S. Constitution, should be subject to a higher standard of scrutiny.
Right.
And I take it some circuit courts, there's 11, am I right, 11 or is it 13?
I think there are 11, but then there's the Federal Circuit and...
The different circuit courts in the federal system some have come down differently, I take it, on this issue. Some say rational basis, some give it the higher standard. Apparently the Second Circuit is silent.
Second Circuit has been silent, yes.
So, and the Supreme Court hasn't ruled on this.
The Supreme Court has not ruled, and and people have different opinions about whether they ever will. I mean, in the Romer case, that was the case about the Colorado's Amendment 2 that had basically said there could be no laws protecting people on the basis of sexual orientation. The Supreme Court struck that down as a violation of equal protection. They decided it on rational basis. When they got to Lawrence versus Texas, and talked about the Texas sodomy law, and they struck it down kind of on both due process and equal protection grounds. They talked about no rational basis. And so some folks try to tie onto that and say, see, sexual orientation gets only rational basis review. I think the better argument is that the court felt that, well, these things don't even pass rational basis review, therefore we don't need to ask the tougher question, and that it's still open at the Supreme Court, which I think is the right answer. But for the lower federal courts, they have to decide, in a way, predict, well, how would the Supreme Court answer this question? We know if we win at the First Circuit Court of Appeals, everybody tells us that case is going to the Supreme Court, even though they only take 70 or 80 cases a year, that once DOMA is struck down as unconstitutional by a court of appeals, the Supreme Court will be compelled to hear that case. And so the First Circuit, I think, probably pretty clearly has in their own mind, well, not only what they think is right, but what does the Supreme Court think is right?
Oh, yeah.
You know, so.
And they don't want to get overturned, certainly.
And presumably they don't want to get overturned, no.
You've been watching Legal Lines. Legal Lines is brought to you by the Massachusetts LGBTQ Bar Association. Our guest today is Gary Busek. Gary, we only have a couple of minutes left, but could you generally tell us what are the arguments for a rational basis? I mean, Paul Clement represented the forces to overturn the health care statute before the U.S. Supreme Court, and then comes and argues this case. I mean, what is his rational basis? What does he tell?
Well, I mean, as I mentioned earlier, I mean, there are Congress's rationales: defending traditional heterosexual marriage, morality, the public fisc, state sovereignty. They have not pushed those too hard. Like I told you, the Obama administration had really abandoned them. The House has pushed heterosexual marriage and procreation a little bit further up the line. So I'll come back to that in a second. But generally, they've been trying to find more neutral sounding rational bases, and whether that is that Congress had a right to protect the status quo, that they had adopted all these laws turning on marital status, and now suddenly the system was being potentially blown up. And they had a right to hit the cultural pause button and say, we don't want to weigh in on either side of this issue. We want to wait and see how it plays out in the states. And so it can be called the status quo argument, the tradition argument. Generally, the courts don't accept those arguments because they just, in a way, restate the proposition. We can exclude gay people because we can exclude gay people.
Yeah.
You know, I mean,
because we always have.
Because it's the tradition. It's what we've always done. It's the status quo. Well, mostly the courts don't accept that as a rational basis, and they've argued uniformity. They want to treat gay people uniformly across the country, and it isn't fair to have some gay people getting federal benefits while many others around the country. Well, you know, that doesn't seem to be the right comparison of who's similarly situated. Anytime you make a rule, you create some kind of uniformity, you know? Yeah. But the question here is, as you mentioned a couple of times, similarly situated people. Are we treating Massachusetts married people the same? And the answer is clearly not. Yeah. So, you know, they have tried a variety of things that sound, I think in a Massachusetts culture, sound less driven by prejudice, that sound like they're looking for something that sounds reasonably good, might appeal to the court and to public opinion, but I think they don't ultimately stand up even to rational basis. They look arbitrary.
Well, certainly. Judge Toro found that.
Judge Toro found that,
and
yes.
Let's hope the First Circuit also finds that, and we'll go to the Supreme Court. Let's hope they find that as well and put this issue to rest.
Yeah, and so these things are, you know, they're moving along at a pace. You know, we had that argument in April. We're going to wait a number of months. We just don't know how long for a decision from the First Circuit. And then we will see what happens after that. But it's going to be a period of time yet.
And if anybody's interested in learning more, they can go to your webpage. I think.
Oh yeah, absolutely. www.glad.org. There is actually a separate DOMA page. I think you just add /DOMA, D-O-M-A. But I think you can get there from the main page as well. Lots of other information about a lot of other issues affecting the community as well.
Great. Thank you so much, Gary.
No, you're welcome.
And
Thanks,
thank you
Tim.
for all your good work. Thank you. You've been watching Legal Lines. Legal Lines is brought to you every third Wednesday by the Massachusetts LGBTQ Bar Association. Tune in third Wednesday of next month for the next installment of Legal Lines. Thank you again. Thank you.